5, 4, 3, 2, 1, start.
The petitioner is seeking direction to the respondent to issue result of the petitioner by treating the answer of question numbers 40 and 70 as correct and not to take into consideration the subsequent change in the answer key in the joint ESIR-CAT November 2015 official answer key booklet A full stop. The admitted facts are that the petitioner applied for the joint research fellowship and eligibility for lecturership conducted by the respondent ESIR in November 2015 in the subject of physical sciences full stop stanza. She obtained 65 marks, which was below 70.76 marks, the cut-off fixed for the unreserved category of JRF, and 65.18 marks, the cut-off fixed for the unreserved category of lecturer full stop. The dispute has arisen with regard to the answers for two questions, that is question number 40 and question number 70 of booklet A full stop. After the conduct of the examination, the respondent uploaded the answer key on its website, and as per the answer key, the options which had been marked by the petitioner were correct full stop. Further, as per the practice, the respondent invited objection in respect of the answer key, and apparently objections with regard to these two questions were received full stop stanza. These objections were referred to a different set of experts who recommended that the options originally prescribed as correct were in fact wrong full stop. These recommendations were accepted and the revised result issued full stop. With this change in the result, the total of the petitioner was reduced by 8.85 marks full stop. This was because had her options been accepted as correct, she would have been entitled for 7.5 marks, and because they were held to be wrong full stop, she lost a further 2.25 marks on account of negative marking full stop. If she had not suffered this loss, she would have qualified the test both for the category of JRF and lecturer full stop. By way of present petition, she has challenged this change in the answer key, which has worked to her prejudice as mentioned above full stop. The stand of the respondent is that it is a organization of the country and has formulated this method of evaluation with a view to promote transparency in its mechanism of conduct of examination to ensure justice to candidates full stop. It has adopted the system of displaying uploading answer keys on its website and inviting representations objections from the candidates pertaining to discrepancy either relating to the questions or answer keys full stop stanza. Further, that the representations received are duly considered before finalization of results full stop. The petitioner has also filed a replication full stop. Along with the replication, the petitioner has annexed the options statedly received from Professor Saqib, who is the professor of physics, Australia University, and Professor Samir from the Oxford University Department of Physics, according to whose opinions the answers given by the petitioner were in fact correct full stop. The situation which has thus emerged is that the first set of experts who set the paper and the last two mentioned experts on the one hand, and the experts to whom the representations were referred by the respondent on the other hand, have different opinions on the two questions in dispute full stop stanza. The claim of the petitioner is that in view of the divergent opinions, it is at least clear that the questions themselves had some defect in so much as there was no clear, unequivocal single answer full stop. Consequently, it is prayed that these two questions be cancelled and thereafter the whole result be reworked full stop. In an ideal system, there would be obviously no mistake in the questions oblique answers, and no candidate would feel cheated or prejudiced on this score full stop. The fact, however, is that these mistakes are not going away full stop. Way back in Allahabad University case, the Supreme Court noticed that normally the answer key furnished by the paper setter and accepted by the university as correct should not be allowed to be challenged, and one way of achieving that would be to not publish the answer key at all, but in that case the remedy would have been worse than the disease full stop stanza. That was the first trickle of transparency which has now turned into a flood and is bringing down the dam of opacity full stop. The Allahabad University case, which was decided in 1982, related to the entrance test of medical for the year 1981 full stop. In Allahabad University case, the Supreme Court appreciated the action of the university in publishing the key answers along with the result of the test, and then held that the answer key should be assumed to be correct, but if any answer was clearly demonstrated to be wrong, it would be unfair to penalize the students full stop. The next case wherein also the Supreme Court held that when the answer given by a candidate is found to be correct and the key answer wrong, the candidate must get full marks assigned to the answer and must be admitted if on the basis of that addition he qualifies for admission full stop stanza. Then 18 years later in Ramesh Vasu case, which was related to the entrance test of medical and dental courses for the year 2004 and was decided in the same year, the Supreme Court underlined that the examining body has to be very careful in setting the questions and preparing the answer key, and a casual approach may result in a situation where directions may have to be issued for taking appropriate action against those responsible for wrong and demonstrably erroneous key answers full stop. In Ranjit Singh University case, which was related to the Punjab medical entrance test for the year 2004 and was decided in the same year, the Supreme Court approved the action of the High Court in issuing directions for fixing responsibility upon paper setters full stop. It was further held that the representations should not be referred to the paper setters but to independent experts full stop. Ultimately, this court held that the main written examination, which was fixed for 1 November 2011, shall stand postponed so that the result of the preliminary examination would be reworked full stop. The division bench modified the order of the learned single judge and held that fresh examination only in one subject was required full stop. The division bench further held that while those appointed on the basis of impugned selection shall be allowed to continue until publication of the fresh result, anyone of them who failed to make the grade on the basis of the fresh examination shall be given a chance to appear in another examination to be conducted by the Staff Selection Commission full stop. The Supreme Court, wide judgment dated 12 March 2012, observed that if the result was vitiated by the application of the wrong key, an appointment made on the basis thereof would also be rendered unsustainable full stop. Further, the court held that the candidates who do not make the grade after re-evaluation shall not be ousted from service but shall figure at the bottom of the list of selected candidates based on the first selection, and further held that it was not incumbent upon the petitioners to implead those candidates who had benefited from the wrong answer key full stop stanza. Further, the court held that the candidates who had already been appointed shall not be ousted and be placed at the bottom of the first list, and the candidates who have crossed the minimum statutory age for appointment shall be accommodated with sustainable age relaxation full stop stanza.